She gave $47,000 to save his restaurant. Then the cameras caught everything. She handed over $47,000 to help save a struggling restaurant. 14 months later, she was sitting across from the owner in a courtroom, and nobody in that room could have predicted what the security footage was about to reveal. The plaintiff was a mid-level marketing consultant at a regional advertising firm, 12 years in the industry, a reputation built on handshake deals and follow-through. The defendant was the owner of a beloved neighborhood bistro, a family-run Italian restaurant that had been operating for over 2 decades on the same corner of the same street. The two had met through a mutual business contact at a Chamber of Commerce dinner in the spring, and what started as casual conversation turned into something that looked, on paper, like a genuine opportunity. The deal was straightforward enough. The restaurant was struggling. Post-lockdown foot traffic had never fully recovered, and the owner was looking for a partner. Not just financially, but strategically. Someone who understood branding, someone who could reposition the restaurant for a younger demographic without alienating the regulars who had been coming since the 90s. The consultant saw potential. She drew up a preliminary partnership agreement. They met 4 times over 2 months. And in early autumn, she transferred $47,000 into a business account the owner had set up specifically for the venture. A renovation was planned, a new menu, a social media campaign the consultant would spearhead personally. Then, 8 weeks later, the owner stopped returning her calls. Standing before the court the following March, the consultant's attorney laid out what appeared to be a clean case of breach of contract. The money had been transferred. The agreement had been signed by both parties. Not a single nail had been hammered, not a single post had been published, not a single dollar had been spent on anything resembling the agreed renovation. The plaintiff testified that the silence was sudden and total. No explanation, no dispute, no request to renegotiate. Just nothing. She had trusted this man, she said, her voice steady but her hands gripping the edge of the witness stand. She had staked her professional credibility on the partnership. The defense told a different story. The owner's attorney argued that the project had not stalled because of bad faith. It had stalled because the consultant herself had become impossible to work with. According to the defendant, she had unilaterally contacted his suppliers, interfered with staff scheduling under the guise of brand alignment, and on one occasion had entered the restaurant's private back office without permission to review financial records he had never agreed to share. The owner testified that he had attempted to raise these concerns twice through email and once in person, and that her responses had been dismissive and, at one point, threatening. He had paused the project, he said, to protect his business and his staff. He had not disappeared. He had withdrawn. The courtroom had settled into the comfortable ambiguity of a he said, she said dispute when the defendant's attorney introduced Exhibit 7. It was security footage from inside the restaurant, specifically from a camera mounted above the storage room door that the owner had installed after a break-in the previous year. The timestamp showed a Tuesday evening in late October, nearly 3 weeks before the plaintiff claimed communication had broken down. The footage showed the consultant entering the private back office, not during a meeting, not with the owner present, but alone after closing, using a key she had never been officially given. She remained inside for 11 minutes. When she emerged, she was carrying a folder. The plaintiff's attorney objected immediately. The footage was challenged on chain of custody grounds, and the judge sustained a portion of the objection, but not all of it. The footage itself was admitted, and the folder, it turned out, contained the restaurant's confidential supplier contracts and wholesale pricing agreements, documents that had surfaced in modified form in a pitch deck the consultant had sent to a competing restaurant group 6 weeks later. The judge took 4 days before delivering her ruling. She found in favor of the defendant on the breach of contract claim. The signed agreement, she determined, contained a material good faith clause, and the plaintiff's conduct had constituted a clear violation of that clause prior to the breakdown in communication. The $47,000 was not awarded. Furthermore, the judge issued a declaratory judgment finding the partnership agreement void in its entirety. The defendant's counterclaim for damages related to the misappropriated documents was referred to a separate civil proceeding. The consultant filed a notice of appeal within 30 days, but it was withdrawn 6 months later without explanation. The restaurant, as of the following autumn, was still open. The owner had found a different investor, a local developer with no marketing background and, by all accounts, no interest in attending Chamber of Commerce dinners. The social media campaign never happened. The new menu launched quietly. The consultant had moved on too. A new city, a new firm, a fresh LinkedIn profile with no mention of the bistro. Here's the question the case leaves behind. If someone genuinely believes they are the right person to save something, does that belief ever justify taking what they were never offered?